Ladies and gentlemen, welcome to the People's Law School. I want you to know that we've brought to you some of the greatest lawyers in America. Tonight is no exception. We have one of Alabama's super lawyers by Thomson Reuters Publishers, and it's Mr. Ron Sykstus. And we also have with him his partner, Amy Tanner. They are with the firm of Bond, Botus, Sykstus, Tanner, and Ezel. I want you to know, Mr. Sykstus, it's great to have him in Huntsville, Alabama. He was from Chicago. He was a JAG officer for many years and has done all kind of cases, but he's here because his wife's from around here. And you know, if mama ain't happy, nobody's happy. So he's here in Huntsville, and he's practicing law at the highest level in regard to security clearances and in regard to federal disability and in regard to the bankruptcies. And he and his partner are going to talk to you about that. He will introduce Amy, but at this time it is my privilege to present to you Mr. Ron Sykstus. Ron,
thank you, Alan. Appreciate it. Thank you. Thank you.
Good to see you.
And like a comedian, I should say, let's give a hand to Alan, all right? Now, I've known Alan for a number of years. Great guy, great family, so I feel blessed to have known him. When I came here from Chicago, I mean, I was kind of on my own. I was with a practice that was based out of Birmingham, so I was up here. I had done some military defense work at Redstone, along with at Fort McClellan, and I was fortunate enough to get to know Alan, so I'm very grateful for that, Alan. So appreciate the nice words. Again, my name is Ron Sykstus. I'm going to talk today about security clearances and VA disability. So I'll cover two topics, and then Amy Tanner will follow me, and she'll talk about consumer bankruptcy. I know on the schedule it said just security clearance, but since we're in this military town, I'd like to kind of cover two different areas because I think, you know, we have a lot of folks that may be involved in both. In fact, by a show of hands, can I see how many people here currently hold a security clearance? Okay. Anyone hold a top secret clearance? Okay. And I was going to ask, so is anyone if you don't hold one now, have you in the past? Okay. And how about veterans? Okay, thank you for your service. That's what I'm always told, so I'll extend that same courtesy. And any veterans involved in the VA disability process or just the VA claim process? And I'll just ask, and just by a nod, yes or no, did you find it frustrating? Okay. So let's start with security clearances. What I tell folks, you know, for our start point is we're here in North Alabama, and it's really a government town. So clearances, the way that works as far as, you know, the government issuing contracts, many of the contracts now, probably 65 to 70% require access to classified material. That's different than it was 10 years ago or so. And I will say that 65 to 70% is probably conservative, and it's unscientific, but I think that's kind of where we're heading. And I think the requirement to do classified material will only increase as we go on. 10 years ago it was maybe 30%, so it wasn't that big of a deal, but it's a really big deal now. As far as the types of clearances, first of all, there's a low-level clearance, and that's not meant in a pejorative sense, but there's a low-level clearance, common access. It's called a common access card. Those are kind of public trust positions that people are working on the arsenal as far as gate guards, maybe people helping out with just entities, you know, Army Emergency Fund, that type of thing. Then there's a secret level clearance. Then there's top secret. Top secret, sometimes people think, well, what's above top secret? Nothing. There are special issues with top secret. For instance, do y'all have SCI or SAP? Okay. SCI clearances are, what are they? Sensitive compartmented information, and then SAP is special access programs. So, you know, you still have a top secret clearance, but you'll be on special events or certain special projects. So as far as periodic reinvestigations for a security clearance, for a secret level clearance, it's 10 years. For a top secret, it's 5 years. So you have to go through the same process again and again. You know, there's always talk with, because that seems a little screwy. Would you agree that 10 years, 5 years, and that's it? Every time something happens, you know, a world event like the Naval Yard shooting 2 or 3 years ago, everyone gets up in arms because the perpetrator there had a security clearance. I think he had a secret level clearance. And then the government says, or Congress says, well, what are we doing? Why don't we evaluate these more? The problem is, and then it kind of goes away, but the problem is the CAF, the Central Adjudication Facility, which is the entity at Fort Meade, Maryland, they hear everything or look at everything regarding a clearance. Now, they're just too overwhelmed, so it kind of goes away, and we're still left with 10 years for a secret, 5 years for a top secret. So getting a clearance, you can't just apply for one and say, I want a clearance to get a job that I read about that requires a clearance. You have to be sponsored. So that's how a clearance starts, where you go to a company and they say, well, we're going to put you in for a clearance. You have to be sponsored, and that's what gives jurisdiction for your clearance. You have to fill out, for a secret and top secret, you have to fill out what's called an SF-86. It is now, as of December 2010, I think it's about 122 pages. To say it's daunting is kind of an understatement, but probably with good reason when you think about it. There's also an SF-85, and that is for that common access card. That's for the lower level clearance, but it still asks a lot of questions, and I'll get to that in a minute. So for me, you know, the evolution of a case for me, if someone puts in for a clearance and gets it, then I'm not involved. So well, what happens from my perspective is someone will put in for a clearance or have a clearance, then the government says, well, we're going to revoke your clearance. You know, and obviously in this town, that's, you know, that causes heart palpitations, right? So what the government will do is say, we're going to revoke your clearance, or we want to revoke your clearance, and it says, it's called a statement of reasons, and in the government clearance world, that's a phrase of art. So statement of reasons, and it'll list specific reasons under a guideline. There's a specific directive, it's called DoD Directive 5220.6, that says it's really everything having to do with a clearance. And it'll state specific reasons of, this is why we want to revoke your clearance or deny your clearance. So, and what it'll do, it'll give an opportunity for a rebuttal statement, or it'll say you can have a hearing before an administrative law judge. And it's also referred to, you may have heard this phrase around, at least North Alabama, it's called DOHA, and that's Department of Hearings and Appeals. It is the central entity that hears all the security clearances worldwide, and these judges travel from Arlington, Virginia down to every location. They're probably in Huntsville 6 to 7 times a year for a week at a time. So the start point with defending a clearance or denial, if it's going to be revoked, is you can submit a rebuttal statement only. So that's the approach someone can take. Or they can also, as I've said, request a hearing before this administrative judge. Now, the administrative judge process, it's an adversarial process. So there's both parties have to present their case. The government has a lawyer. They'll always have a lawyer present, and really that's all these lawyers do. A lot of them, I mean, they're talented lawyers. They're former JAGs, a lot of them, and that's what they do. They travel the world pulling clearances. As I tell my clients, as nice as they seem, they're not your friend, but they're good people, and like I said, talented lawyers. The applicant, the person applying for a clearance or having his clearance revoked, can represent himself. He can hire a lawyer at his own expense, or he can have a third party do it, a friend or a family member. The hearing itself is heard within 150 miles of where the job is. So as a general rule, all of the hearings here will be in Huntsville or Decatur. If you can believe it, a lot of times they can't find a government building here to hold the hearings, so they'll move them to the federal court in Decatur. The administrative judge cannot issue subpoenas, so he can't compel testimony, he can't get documents or anything like that. So really, documentation or witnesses is voluntary, and the applicant has to bring that if he wants to have the judge hear that. There's a wide degree of latitude as far as getting in evidence. So when you if you got to a hearing, the federal rules of evidence don't apply, but they're used as a guide. So the point is, a lot of stuff come in.
Is there a discovery process?
No, because the government's going to have everything they have. So they're going to give you everything. And from that perspective, yes. I mean, we have to disclose whatever we're introducing. So So my view of a case is to always, always, always request a hearing. And I say that without equivocation. I think submitting a rebuttal statement is a waste of time. I think that's as good enough as clearance is denied or revoked. And you can approach it two ways if you request a hearing, and you can approach it like a regular criminal defense postured case, and that is the applicant didn't do this conduct that the government's alleging, and fight it that way. Or you fight it that the applicant did do the conduct and you explain the conduct. And I will tell you, I've never had a case where it was the former. It's always the latter. I mean, the government has this stuff. I mean, they wouldn't be addressing it if it wasn't a problem. So, but we'll get there in a second. Not all is lost. So what I like to do in a case, again, we're at a hearing. I like to bring in supporting witnesses, and we'll bring in two types of witnesses. There'll be character witnesses. If y'all have served on military, I don't know if you've ever served on a military panel, military jury, there's such a thing in the military called the good soldier defense, where it may not be germane to the case, but it's, what's this soldier like? It's a great defense. So I use the same type of analysis here. Let's bring in character witnesses. Employer, bosses, supervisors, co-workers. If I have someone who's faith-based, I'll bring in church members. I just talked to a gentleman today. We're probably going to bring his pastor in. I love to get pastors or priests in if we can, if the person is, tied to his or her church. We'll also get awards, diplomas. I've had some cases in the last 2 years where I've had Bronze Stars. And believe me, I'll raise those like a flag. And I had one with a Bronze Star with a V device, right, for valor, and it doesn't get any better than that. So, and all those folks have kept their clearances in the end. So, just to take the mystery out of it. So, I also get performance appraisals. Especially for government employees, and a lot of the bigger contractors issue yearly performance appraisals. As long as the person is doing good work. I remember when I was in the military, I looked a lot better on paper than I was. They're inflated, so we bring them in, we introduce those. So I mentioned that DoD Directive 5220.6. So each guideline, there are different factors of why the government's concerned. Every one of them has mitigating factors. So even if the conduct happened, you can mitigate it by going through these guidelines. So that's why I said I'm not concerned that the conduct happened. We can work through that. We just need to talk about it. A lot of times some of the conduct it's embarrassing, but it is what it is, and it just like anything else, if you wade right through it and talk about it, it takes the sting out of it a little bit. There's this guideline E, and that's called personal conduct. It's the worst one. I hate to see it because the government can really, this personal conduct, that's where a lot of judges, if they're going to pull a clearance, will hang their hat on it. And it's conduct involving questionable judgment, untrustworthiness, unreliability, or dishonesty. But there are ways to mitigate it. And I won't go through each one, but suffice it to say, it's if the event was old, if there's a falsification, did the person make a good faith effort to quickly try to rectify it and explain him herself or herself? And that kind of brings me to that SF-86. So we talked about filling out the form, the 86 or 85. 85 is just a shorter form, but it asks a lot of these same questions. If there is a misstatement on that SF-86, they're going to bring this guideline E charge, and that's, in a lot of cases, that's a killer. I mean, it's the worst case that I don't want to see is that you made a misstatement or an omission. And some of the questions that are asked, and this is where this worries me and worries the applicant when they're filling this out, is this is in the last 7 years, all right? And a lot of times as you go through that document, as you all will recall, you go through that document, it'll say in the last 7 years, then it'll say ever, last 7 years, last 7 years, last 7 years, ever. And believe me, I've had a number of people get tripped up on that because the government comes back and says, well, you answered this question where it says, have you ever, fill in the blank. And they said, no, I thought that you meant the last 7 years. Well, you lied. That's a big problem. I mean, bigger than you would think. So some of these questions, in the last 7 years, have you been issued a summons, citation, or ticket to appear in court? Have you been arrested by any police officer or sheriff or marshal? Then it'll be these series of questions. Have you ever been charged with a felony offense? Include any offenses under the UCMJ. I've had 2 or 3 guys in the last 2 or 3 years who were charged felony charges under the UCMJ, but were acquitted, or maybe it was pled down to some de minimis misdemeanor, but they answered no, and now the government says you lied on your SF-86. I mean, it's a really big deal, because the question is, have you ever been charged with a felony offense? Have you ever been charged with a firearms or explosive offense? How about this one? Have you ever been charged with any offense related to alcohol or drugs? So if there's a DUI conviction, I don't care if it's an 18-year-old. I have about to be an 18-year-old and a 21-year-old, so I'm in this area. A minor in possession. My son's going to the beach next week, and we talk about it a lot, right? You know, I don't care if it's an 18-year-old minor in possession charge, you have to disclose it. If you don't, I mean, they're going to circle back around, because that is an offense regarding, you know, alcohol or drugs. In the last 7 years, have you illegally used controlled substances, THC, marijuana, crack cocaine, prescription drugs, illegally used prescription drugs? And I've had cases where it's their own prescription drugs that they, you know, misused, right? So that becomes an issue. Use of alcohol. Has alcohol ever had a negative impact on your life? So it's a pretty nebulous question, but, you know, unfortunately it affects a lot of people. So, you know, to answer no to some of this stuff, and then it circles back around, have you been ordered, advised, or asked to seek counseling or treatment as a result of your use of alcohol? Again, it's a pretty open question. A lot of folks have been, you know, asked or advised, spouses, employers. Financial record. When you submit this SF-86, you literally, you know, just open the door to everything that's out there in your life. Have you filed a petition under the Bankruptcy Code? Have you had any possessions of property voluntarily or involuntarily repossessed? Have you failed to pay federal or state tax returns, or listen to this, or to file a tax return? I've talked to probably 4 people, we're at March, 4 people this year with security clearance issues who haven't filed tax returns for 2 or 3 years. And I had one who answered, no, I haven't failed to file. Whoops, yeah, he did. And now we've got that guideline E, that, you know, lack of candor. So, you know, that gets kind of tricky. So those are kind of the questions that they're asked. How about one more financial one? Have you ever been over 180 days delinquent on any debt? And that's an ever question. It's not every 7 years was, have you had a judgment entered against you? Have you had a lien against you? In our world, in our consumer world, liens are the worst thing in the world. And they can stay out there for up to 20 years, at least in the state of Alabama. So, you know, I've told you that's the bad stuff. But again, these guidelines also they allow for mitigation. So, and this is the exact mitigation for financial conditions. The behavior was not recent. It was isolated. And how about this one? The condition that resulted in the behavior were largely beyond the person's control. And I'm kind of reading this rote because I don't want to miss something here. Loss of employment. You know, we've all been there. A business downturn. I've had a number of folks who start their own business, and, you know, for one reason or another, it doesn't work. You know, and then maybe they try to get a clearance and get back into the government work, and, you know, you can explain it. So a business downturn, unexpected medical emergency, or a death, divorce, or separation. So that really covers the reasons people fall into debt. And it's very rare, and it even addresses if there were gambling issues or something like that. I've never seen that. It's always the function of a divorce. You know, people maybe were relying on 2 incomes, something like that. Loss of business, like I said. The person has received or is receiving counseling for the problem, and there are clear indications that the problem is being resolved or under control. That is code word or phrase word for bankruptcy is okay. And that's not a promotion of bankruptcy, but a lot of people with a clearance are like, boy, bankruptcy can't do it. Well, what's worse than I'm sitting on liens, taxes I can't pay, and debts and collections and lawsuits, or you use bankruptcy and you address it. So it's really okay. And what I tell folks, and both types of bankruptcy in a clearance context are okay. At Chapter 7 or Chapter 18, Amy will talk about that. Here's where I've seen people run into issues. Multiple bankruptcies in a lifetime can be a problem. I've seen a case years ago, but so this always sticks with me. Two bankruptcies, 15 years apart, was a problem for the administrative judge. A bankruptcy and choose your poison, a couple of DUIs, maybe a misstatement, that can all be a problem. One bankruptcy in a lifetime, not a problem. You'll have to address it, you have to disclose it. I always tell folks when we file for bankruptcy, we tell them, let's disclose it to your FSO immediately. The FSO is a facility security officer. Every job, every government entity, every contractor, every subcontractor who deals with classified material has an assigned facility security officer. So we get the petition to them. We have our client explain how you got here. That should put it to rest. And it takes a lot of weight off of people because especially with a clearance, the first inclination, I can't ever do bankruptcy. I've got to live with the calls, the letters, the harassment, the lawsuits. Yes, sir.
Back to the 180-day thing with the debt. One of the other attorneys came in and was saying that the people put in for medical claim in their insurance, and the insurance company didn't pay it. And it could run out to 180 days or longer. The person doesn't even know it. But yet it goes out on their credit report.
Well, let's address that. That's a good point. I mean, that's something you have to dispute. The law that deals with the credit report is called the Fair Credit Reporting Act, and that is everything that relates to a credit report. So you have to dispute it, and the way you dispute it, you can dispute it with the provider, whoever's providing or furnishing the information. You dispute that, and then that's something you would bring if someone raises this issue as it relates to a clearance. Here's my dispute letter where I said, and you're fine.
What I'm saying is that they didn't know it, and then it became an error on that report.
Okay. How would they know it? Before anyone fills out, this is probably one of the best things or most important things. I don't know if it's the best, but one of the most important things I'll say. Before you're applying for a clearance, get your credit reports. And only get them when the government pulls, they always pull a credit report when they do what's called the single scope investigation for a secret or top secret clearance. They're going to pull your credit reports. They use this, you've seen it, Amy, some ancient form. It's called a tri-merge report, and you can't even read the copy. There's tons of mistakes in it. Get your own credit reports. And the way I tell people to do that is annualcreditreport.com is the government mandated site that FTC said that all Americans are entitled to one credit report per year from each of the 3 credit reporting agencies, Equifax, Experian, and TransUnion. Do not buy them directly from the site. I won't get into why, but that's a real big deal. When I say from the site, from the credit reporting agency, get the free ones. A lot of people, the best way, and this is Wrote Money magazine, if you really want to check your credit report, get one every 4 months, right? You can get the free one every 4 months, keep it rotating. Look at it. If there's a problem, dispute it. But as far as filling out that SF-86, that should be step 1, or the SF-85. Step 1 before you do anything, get those free credit reports from those 3 ways. You can do it online here through annualcreditreport.com. You get one look. If you skip that look or your printer's not working, you can't go back again. You have to then buy them, and you get into this twisted issue that I just talked about. So I tell folks either make sure your printer's working, print them when you see them, or better yet, there's a form that's at the site, a one-page form you can fill out and request them in writing. So that's how you get around it, and that addresses it on the front end. You know what the issues are, and by then you should know someone's not paying. You'll have gotten some collection letters to your question. They'll know that there's a problem. Medical providers, in my experience, will move pretty quick they don't think they're getting paid. So alcohol consumption. So conduct that can mitigate that, and I've had a number of clients, unfortunately, I mean, multiple DUIs, just issues happen. I mean, our country has a problem. It's, hovers between 15 to 20% as far as my reading in the studies. So things happen, but you can mitigate that by alcohol-related incidents do not indicate a pattern. The problem occurred a number of years ago, and there is no indication of a recent problem. Positive changes in behavior supportive of sobriety, and here we go, following a diagnosis of alcohol abuse or dependence, because if you answer correctly the SF-86 and there's been some alcohol issues, the government's going to get those medical records, and they're going to ask for them. And if there's a diagnosis of alcohol dependence or abuse, they're going to raise this guideline G issue for alcohol. So following a diagnosis of this, the individual has successfully completed inpatient rehab along with aftercare requirements, participates frequently in meetings of AA or similar organizations, and has abstained from alcohol for at least 12 months. A lot of times if I have someone that's, in recovery and doing well, they go to AA. I mean, I've had sponsors kind of reveal or let go of their anonymity and come in and testify that, hey, I'm his sponsor, he's committed to the program. So I'm a big believer this way in AA. It's a good thing. And these judges really, I mean, they honor this. I mean, they honor the mitigation. Kind of the same analysis for drug involvement. It allows for inpatient rehab. You can't do it again. So once you have this issue, you go through the rehab, go to AA, NA, I don't care, something with an A in it, that will help. And it'll help on a lot of fronts. Probably the least that it's going to help is security clearance, but it will be helpful here. A demonstrated intent not to abuse illegal drugs in the future. So if I have a drug case where someone's gone through rehab, is doing well, I'll have them do an affidavit that says, I am stating I will never use illegal drugs again, and the punishment will be my immediate loss of clearance without anything further. So it's important. The judges want to hear that. So, and then there's also criminal conduct. And it's the same kind of mitigation. So there is stuff, even if stuff happens in the past, you can mitigate it, the length of time, you've gotten away from associates that you were with at the time. So just to sum up the security clearance, 2 or 3, 4 points here, and that is answer those SF 86 and 85 questions as exacting as possible and as thoroughly as you can. And provide an explanation where if you have a concern, I'll counsel with people that always have, or many times have, 2 or 3 specific questions. I don't know how to answer this one. The stuff, have you traveled outside the country? Well, yes, I went to Ireland. Great, I mean, that's easy. But it's the stuff, what if I had a minor charge that I was told was expunged? I mean, do I disclose that? Stuff like that, just make sure those questions are answered pretty exacting. And where you're concerned, provide a detailed explanation. So, disclosure is the key, and that's what it's like 3.5 pages of instructions. It says full disclosure. If you get to the point where there is they're trying to pull it, again, as I've said, always request a hearing, bring a case as big as possible, and then finally, I do believe in having someone there with you. And it doesn't have to be a lawyer, and I understand money's tight, especially if it's a financial case. That may not be viable. Have a friend or someone at work or someone you trust that can come in and speak on your behalf. It just sounds, if I say, listen, Judge, I'm a really good guy. Let me tell you how good I am. I mean, I hate how that sounds, right? Versus me saying, let me tell you about Alan Brinkley. That guy, he's the salt of the earth. He's a great guy. He does great things here in the community. That's a lot better than me or Alan talking about that individually. So that's security clearance in a nutshell. I want to hit VA disability and then leave enough time for Amy. If any questions, we can do that now. Good. So VA disability, again, for a lot of veterans in our community, big deal. Let me talk about two types of VA claims. There is a pension claim, not very well known, but it's wonderful for veterans who aren't doing too well. And it's a means-based program. And what it allows for a pension if it's a non-service connected disability, you weren't injured in service, and we'll get to that in a second. If you're 65 or older, or totally and permanently disabled, and these are general rules, the VA doesn't really publish it for who knows why, but generally if your net worth is below $80,000, and that's exclusive of a principal residence, vehicles, personal vehicles, household goods, and income is 1,000 or so a month with, and that's pure work, it doesn't really count Social Security. You can get a pension if these are met. If you have an honorable discharge or a general under honorable conditions discharge, right? No dishonorable discharge, as long as it's a general or better, and you served up to September 8, 1980, if you served 90 days on active duty, 1 day of which we were at war, you can qualify, or your veteran can qualify. After September 8, 1980, it's 24 months of active service, 1 day of which had to be at war. And you could be stateside, you could be ski patrol, Fort Drum, you're fine. You didn't have to be in any type of war zone. And listen to these dates. I mean, For Vietnam, I won't go back to Korea. I give you some concession. You all look a little younger than Korea. Vietnam is 65 to 75, so that was a time of war for this calculation. August 1990 through the present, we're at a time of war. So 26 years. I mean, so we fit, if someone has served. So that's just something to consider. It's great for, we do some work where we can for homeless veterans, and that's a great fit for that. So, or, for folks that just aren't doing too well, veterans. VA disability claims. So these are the service-connected disability claims. So what a veteran needs is a current disability, needs an event or injury in service, and there has to be a nexus, a service connection from that event to the current disability. And I always tell folks, sometimes, well, people ask, well, do you put in claims for veterans? I don't. Veterans do that themselves, and frankly, they don't need me or they don't need anyone if their claim is granted, right? And here's what I always think. Veterans know what their disability is without question, right? They know if they were hurt, if they were injured on service or during service. So I always tell veterans that, especially if they want to tell me a lot about the disability itself, I'm really not that concerned about the disability. I'm more concerned with the process, because I think the process is way more important than the claim. The claim will become important, but if you blow the process, it will be over as far as your claim. So what I tell folks as far as filing the claim, and there was a very big systemic change last March, where you now have to submit a VA Form 210966 to file your claim. You submit that in a regional office. You say, VA, I want to claim for VA disability. This is what's wrong. And that's how it starts. If it's granted, great, you're good, and you're in play as far as the VA. Though it may take a while, but you're in play. I say that because I'm trying to get my son is in the reserves, and we're trying to get his GI Bill. And I'm finding I'm a frustrated veteran like all my clients now, because we can't get that going. But so if the claim's granted, great. If it's not, then you have to file a notice of disagreement. It used to be you just file that notice of disagreement in writing. They've now changed it to use a specific form. It's this Form 210958. This is the critical part. I said the claim process is important. It has to be filed within 1 year of the denial notice. If they say you file your claim, VA says no, 1 year you have to file that notice of disagreement. Failure to do so means the claim is final and unappealable. After that, the VA generally sits on it another year, and they'll come back and say, all right, we're going to now issue a statement of the case, which is essentially a regurgitation of their first denial. You have to file from that statement of the case a VA Form 9. Failure to do so means the claim is final and unappealable. And that's such a big deal. And I tell veterans, that to me, that probably occupies 60% of the talk I have with veterans. Where are we at in the claims process? Did you file your notice of disagreement? No, I've just filed a new one. The VA is going to come back and say the claim is final and unappealable, and it's a mess. So, so here are my tips for filing a VA claim. Anything that's mailed to the VA, it has to be done by certified mail return receipt. I had cases myself. Everything I send to the VA on behalf of clients is done by certified mail return receipt. On the front side of the green card, I will write on it, the card that comes back to me, to Ron Sykstus at my address, will say, notice of disagreement for veteran Ron Sykstus. I'm going to tell him exactly what I'm sending. I have 2 cases right now where the VA says, sorry, veteran, you never submitted this, and the claim is done, it's dead, it's final and unappealable. I say, well, wait a second, here's the green card where we say exactly what you don't have. It's crazy. So certified mail return receipt, keep a copy of everything that you get from the VA, and certainly a copy of everything you send. And this is simple stuff, but date the stuff you send. Without question, just to make it, you want to do these is almost like a 5th grader story. So you're telling exactly what a 5th grader could recognize what you're trying to do. Service connection, that's the big deal for veterans. For these VA disability claims, service connection most often is everything. The VA a lot of times will say, you may have a current disability, but it's not related to your service. What I tell folks, and what has been very good for us over the last 3 or 4 years, are buddy statements. If you get a statement from your buddy that, every veteran can pick out 2 or 3 guys or girls they were with, doing whatever they were doing, whether it was skiing, running, or in combat, you can get a buddy statement that says, and I would tell veterans, remind your buddy what happened. Remind them how you couldn't sleep. I have one guy who says he's got terrible sleep apnea. I'm like, then I bet you the guys that you were in your same bunk hated sleeping with you. And he was sure enough, he's reached out. He's got now 4 statements of saying we couldn't sleep. This guy snored so loud, was up all night, et cetera. So really important. And how do you get the buddy statements? Facebook and Google. I mean, it's been a great, great tool. It's a way for veterans to reach out. One last thing, and this is just good for veterans for posterity's sake, is you can get your entire military record by submitting an SF Form 180. In your materials, I've got one of those. If veterans just want to get it, like I said, for posterity. This SF Form 180 will allow you to get everything as it relates to your military service. It'll take some time, and sometimes they talk about the Great Fire in St. Louis. You heard of that? That where records were destroyed.
But you got 1 year for the veteran,
right.
VA, and then it takes too long to give you your military record.
Well, but you get them separately. You're going to get those separately. So, yes, sir.
Can I get a copy of my father's military records? He's deceased, but was in during 36 to during World War II.
Yeah, you can use that form. I say that with some hesitation. My grandfather served in Korea. My son was applying for a scholarship. If you were a descendant of a Korean War veteran, my grandfather was. They never sent it to me. But you can try it. So right now that gives me about 20 minutes left, or 20 minutes left, Amy. So at this point, let me introduce Amy Tanner. Amy's been my partner for a number of years. Her bio is in there, but I'll just tell you a couple things about her. She was born and raised and educated in Montgomery, worked full-time all through college, all through law school. A brilliant lawyer, and I can't say enough about her. Her work ethic is unbelievable, but beyond that, she's a former state chair, or Alabama state chair of the National Association of Consumer Bankruptcy Lawyers. And I would say, I'm biased, but there's not a lawyer in the state that knows more about consumer bankruptcy than she does. I mean, she's an encyclopedia, so I use her as a great resource. So without further ado, thank you.
Thank you, Ron, for that glowing introduction. And so we'll just jump right in tonight, since we've just got a few minutes left, and just kind of start with a general question. What is bankruptcy? And most people think they know what bankruptcy is, but it's usually not what most people think it is the issue. It is taking care of your debts, or handling your debts. Kind of what I like to say is the bankruptcy process is actually designed to help individuals and sometimes businesses get protection from their creditors. It's not so much of getting rid of the debt, it's getting protection from your creditors. Bankruptcy is provided for in federal law. Your right to file comes from federal law. And all bankruptcy issues are handled within a federal court, a federal court judge. If I'm being honest, this is what I've done for my entire 18 years of practice. I've never set foot in a state courtroom. I've always practiced in federal court. So the next thing I'd kind of like to talk about is who files for bankruptcy. And this is one thing, and I'm going to go off on a soapbox. It's not really bankruptcy course 101 for a second, but it's something I like to get out there when I'm talking to any group of people. If you've heard me speak before, you've heard me say this before. I'll talk about this anywhere, at the gym if I'm asked, at the mall if I'm asked, if somebody finds out what you do, at a cocktail party if I'm asked. There's such a, and it's gotten less over the years, but there's such a bankruptcy leaves kind of a bad taste for people, so especially if you've ever been on the creditor's end. But I'm here to tell you right now, I've been doing this for 18 years. I have never, ever, ever, ever seen anybody who went out and just ran up all these bills and ran into my office and said, oh, I ran up all these bills and I bought all this stuff and now I want to file for bankruptcy. That is not the way it works. Everybody, may have a time, when they need bankruptcy. I sometimes say we just all live a few feet from the other side of my desk. You never know what's going to happen in your life. Are you going to lose a job? Is your spouse going to lose a job? Are you going to get injured, and not be able to work? Are you going to have medical bills that are not covered by insurance? those are some of the main things, and probably the main two things I see for who files bankruptcy are the people who have had a job loss, unexpected job loss, or some type of medical problem where either a combination of they missed work or they had a pile of medical bills they just couldn't afford. And let me tell you, medical providers are huge collectors. They are going to beat you up. They are going to suck your blood and take your children to get these debts paid. So they're one of the biggest people that push people towards us and what we do. Actually, bankruptcy goes way, way back. I'll give a very brief history of bankruptcy. History's never was my strong suit. It goes as far back as the Bible. You can find a reference to forgiving debts every 7 years in Deuteronomy. Let's see, I think it's chapter 15, verses 1 and 2, talks about forgiving debts every 7 years. So there's your first taste of bankruptcy right there back in the Old Testament. Come forward to the New Testament, you see another reference to it in Matthew during the Lord's Prayer. Forgive us our debts as we forgive our debtors. And actually, as far as, I think you think I'm stretching it there. As far back as, and the Constitution allows for Congress to create uniform laws of bankruptcy, which is what we have today. We have, in the U.S. Code, we have Title 11, which is the Bankruptcy Code, or as we were kind of referred to today, in 2005, they rewrote the code. It's called the Bankruptcy Abuse Protection and Consumer Protection Act of 2005. That's a tongue twister for me, so I actually kind of have to read it. But that's something you can find real easily on the internet. I think the site is even in the handout we gave out tonight. If you have any interest in going and referring to any of the sections, I probably won't refer to many sections themselves tonight. But it's as far as by section, but you can go there and read the whole code if you so desire to do so. It's an easy, free source on the internet. What can bankruptcy do for people? Okay, what bankruptcy can actually do for people is eliminate a legal obligation to pay some or all of your debts. Okay, to give you relief. It can stop a foreclosure that you have pending on your house, so that you can try to reorganize your debts and keep your homes. It will not automatically eliminate some mortgage and liens, but it's something you can do through bankruptcy. And we'll talk about these little points more in detail when we separate out and talk about the various chapters of bankruptcy. One big thing it does is stop creditor harassment. The minute you file a bankruptcy with the bankruptcy court, your creditors can no longer contact you direct anymore. They have to go through your attorney if you have one, or if you don't, which I advise you should, then they just can't get a hold of you directly to try to collect on the debt anymore, okay? Those are kind of some big lawsuits out there. It also will stop wage garnishments and any other kind of collection efforts, okay? What I tell most folks, short of a foreclosure or a repossession, a creditor can't do anything to you I can't undo once we file a bankruptcy with the bankruptcy court, unless they've already actually taken your property, and then I can always get it back. Some types of bankruptcy, the Chapter 13, we'll talk a little more in detail about. You can actually consolidate your bills and lower your monthly payment on debts, which makes it easier to pay your creditors back in an organized fashion. Some things bankruptcy cannot do, as I mentioned before, it can't eliminate your right to pay every secured creditor that you have. You know, car loans, house loans, you're going to keep those items, you do have to pay for them. In most circumstances, some things that you can't get rid of or discharge, which is the official word for getting rid of debt in a bankruptcy, is child support, criminal fines, and for most folks, student loans and taxes are not dischargeable in a bankruptcy. There are some rare exceptions and circumstances to be able to discharge those things in bankruptcy, but in my 18 years of doing this, I don't see it very often. It's pretty tight, stringent details for that. Going into the types of bankruptcy cases, actually there's several different types of bankruptcy. I'm focusing more tonight on what the consumer bankruptcies are. There's several more that are open to municipalities and businesses. The one most people, I always say this to clients, most people think of when they think of bankruptcy is Chapter 7, or people call it straight bankruptcy, a fresh start, just getting rid of debt. And that is where you can get rid of most of your debts or discharge most of your debts. Chapter 13 is a debt consolidation style bankruptcy or reorganization, where you can sometimes consolidate all of your creditors, maybe keep all your property. You may want to choose to give some property up in a Chapter 13, but you can reorganize everything so you can make a payment to your creditors that you can hopefully afford. Chapter 11 is another type of reorganization. Most people consider that as a business bankruptcy, and for the most part, a business, a small business, or well, a large business for that matter, large corporations would use the Chapter 11. There are certain circumstances where an individual person would file the Chapter 11 bankruptcy, depending on what the debts are or some other, relationships they have with creditors and things, or whether or not they have a small business, maybe that they're just a sole proprietor. Some of the common things common terms and common theories that go through both Chapter 7 and Chapter 13 I'll talk about, and then I'm going to separate out and talk a little bit about one chapter versus the other. The biggest thing that I mentioned without calling it by name is the automatic stay. And I mean, if you go look at the code, you can find all the details of that in section 362. And that is what stops the creditors from collecting against you. That automatic stay goes into place the minute the bankruptcy petition is filed with the court. Nowadays, we've got electronic filing. Basically, we push a button and it's done. So at that moment, creditors can't call you. They can't come to your house and repossess your car, knock on your door. They can't proceed with a foreclosure. I've stopped foreclosures literally hours before they're supposed to happen by filing a Chapter 13 bankruptcy. The other big key that I've mentioned the term several times is the discharge of the bankruptcy. That's the completion. That's the end result. That's what you strive for the whole time you're in bankruptcy, whether it's Chapter 7 or 13. You're wanting that end result. You want that discharge because you rebuild from that discharge. The discharge means you're done with these creditors. You've done what you promised to do. You've either actually wiped the debts out in Chapter 7 or you've complied with the terms of your payment plan to get to the end result and complete the case. I actually call this is my made-up term for it. I call the discharge. I tell my clients it's your bankruptcy birth certificate. Hang on to it just like you would your real birth certificate. Future creditors may want to see it. It's an actual little piece of paper you get that says you've been discharged. Some other things, all types of bankruptcies in different capacities have a trustee and the trustee is the administrative portion of a bankruptcy case. That's the supposedly kind of unbiased individual who oversees the process of the case to make sure, to follow up, make sure you have disclosed everything you should disclose in your bankruptcy petition, make sure that if there are any assets that could be sold to pay creditors, that he or she would take those and sell them to pay the creditors. They just do the administrative portion of the case, and they're paid from a portion of the filing fees or court costs that someone would pay in for a case. We have both secured creditors and unsecured creditors, which most people know what those are. Secured creditors are creditors that are going to have collateral, your cars, your houses, your RVs, your boats. In some situations, personal goods, depending on what those are, furniture, stuff like that. Unsecured creditors are going to be your credit cards, medical bills, signature loans, payday loans, things like that. And these types of creditors are handled different ways in each type of bankruptcy. So moving on into Chapter 7 bankruptcy, like I said, what we consider straight bankruptcy, or even a liquidation is a technical word, because technically in a Chapter 7 bankruptcy, if you own any assets that aren't exempt property, of which you're allowed to own a little bit of property and file a Chapter 7 bankruptcy, then the court would step in and possibly sell those assets or force you to sell those assets and distribute equally under your bankruptcy the portion of those proceeds to pay the creditors if you're unable to pay the creditors, which is why you came to bankruptcy. In Chapter 7, what we generally wipe out or discharge, as I mentioned, credit cards, signature loans, medical bills, payday loans, anything else you can think of as an unsecured creditor. Now, if you've got a house or a car, you don't always lose that house and car. Some people think you do. Or you aren't always allowed to keep your house and car. Have some people come to me sometimes and they say, well, my friend told me that they can't take my house and car. They have to leave me one of those, a house and a car. No, who they're referring to as the big bankruptcy people, do not have to leave you a house and a car. It depends on your actual circumstances. If you own a home and a vehicle and you have liens or you're paying notes on those vehicles, you can continue to pay those notes. That's called reaffirming a debt in a Chapter 7, and basically that's what you're doing with that creditor, is reaffirming the terms of your actual contract with them. So I tell my clients on that, keep making the payment like you never saw me, okay? And generally the reaffirmation is no problem. You keep your house and car. Now, that can change a little bit if you have equity in your house and car. If you've got equity, then it becomes one of these assets I mentioned a little while ago. And that's something that the court could step in, or the trustee would actually step in and possibly sell that asset and distribute under the Chapter 7 what they could to each of your creditors. And they do this to any property that has any value up to it. A Chapter 7 trustee might take to sell to creditors. I mean, it can be things as much as certain jewelry, you know, collections of some sort, baseball card collections, I don't know, football jersey, Alabama football collections, you know, things like that, anything of value that a trustee could take and sell. You mostly see these values in real estate or land or a home or something like that, but there are other things that can do it. Let's see. As I mentioned before, with the Chapter 7, we don't usually think of Chapter 7 if you're dealing with taxes or student loans, because except under rare circumstances, as I mentioned, a disability or some way, a certain way not to pay, can you discharge a student loan? With taxes, there's various things for qualifications. I'm not going to get into the details of all that, but they're rarely dischargeable because they have to have been filed for at least 3 years, no tax assessed in 240 days. There's some other criteria involved with determining whether or not tax debt is dischargeable. I rarely see a person who comes to me who has tax debt who's done all the things just so, kind of like Ron mentioned about the process, that they've done the process just so to make their taxes dischargeable. Although it does happen on occasion with the Chapter 7. Another way to handle some of these issues that can't be handled in a Chapter 7 is to file a Chapter 13 bankruptcy, which I said is more like the debt consolidation style of bankruptcy. A debt consolidation, Chapter 13, can last anywhere from 3 to 5 years. You can include just about any kind of debt in that bankruptcy to be paid except for criminal fines. That's usually the only one I can think of off the top of my head to tell people that you can't pay through a Chapter 13 bankruptcy. You can pay taxes through a Chapter 13 bankruptcy. You can pay a student loan through a Chapter 13 bankruptcy. So if you've got collection efforts from the IRS or the state with tax or the student loan folks, you may look into filing a Chapter 13 to kind of manage it a little better without them levying your pay or anything like that. Two different kinds of Chapter 13s we generally think of. One is called a pro rata payment plan. Maybe you can't afford to pay all your creditors back in full, but for various reasons you want to try to pay as much as you can, or you're using the 13 as an avenue to stop the foreclosure, like we've mentioned, and keep your home or keep your car from repossession. Then you may not be required to pay all your creditors back in full. There's also something called an extension plan, where you would pay all your creditors back in full at 100%. We generally see those plans if somebody's just trying to protect assets. That's one way to protect assets. If you pay all your creditors in full in this organized plan over the time period, then the trustee is going to say hard-pressed to go, let me take whatever and pay these off sooner. If you commit to that 100% plan, that's usually not a problem at all. I'll briefly mention on Chapter 11 for individuals one thing. The main reason I see an individual need to file a Chapter 11 reorganization is because they're over the debt limits allowed for Chapter 13. We call it the BAPSIPA, the Bankruptcy Abuse Protection Act that I was telling you about, does set certain limits that you have to meet. Just off the top, let's see, the unsecured debt limit in a Chapter 13 is $383,175. Believe it or not, that's the one people usually hit. Not very often. I see maybe one person a year hit that debt limit for unsecured debt. The secured debt limit is $1,149,525. I don't think I've ever had anybody hit that limit on the secured debt limit as far as an individual, if there's not a business involved with the situation. So those are a few things, just Chapter 13 pitted against Chapter 7, a little quick reasons why you might want to do one or the other. Some other things that apply to both of these things and that were also changes in the 2005 Act. There were big changes in the 2005 Act, and I've harped on that for, 10, 11 years now, how it really changed our practice. And for the most part, it just made more paperwork for us. The two big things I think that that had an effect with the consumers in the change in 2005 was it required credit counseling and financial management, which are two courses you have to take in order to file or discharge from any type of bankruptcy. One's before you file, one's after you file. Another thing is the means test, or qualifying to file for bankruptcy, so to speak, under median income. Everybody can qualify some way or another. People will call me on the phone and say, well, I don't know if I qualify for bankruptcy. Well, you qualify. It just depends on for what chapter, how you qualify. The median income is what you have to pass. The median income, just right now, the median income for a one-earner family, for instance, for our state is $41,420. So if you make more than that, you would not qualify for Chapter 7, but you would qualify for Chapter 13. So that gives you an idea of what type of incomes we're talking about. You know, folks will come in and I'll say, well, you make too much money to file a Chapter 7. They're like, what? Where does it all go? And that's the thing. It's a pretty stringent, you know, testing as far as, you know, the amount of money you make to be able to file which chapter of bankruptcy. So if you don't qualify for a 7 under that median income, we look at a 13. Another thing that would apply on that means testing or median income, it's actually a test. I equate it to a tax return. Put your gross income in, you take a lot of expenses out, and you come down to a bottom line, more or less, of this is what you pay your creditors. That said, you know, you do get some deductions. What I like to say is they're reasonable and necessary deductions, what the IRS standards have set. So it is kind of like a tax return in that aspect. There are time limitations between filings. They get a little convoluted since the 2005 Act. The main one is 8 years from 7 to 7. So if you're going to wipe your debts out, you can only do that every 8 years. If you're going to do a consolidation and pay your creditors back through a 13, you can actually do that every 2 years. There's some other limits between 7 to 13 that get a little more convoluted with case law. Let's see, I think I'm running out of time now, so I'm going to wrap it up really quick. A couple of things that all folks have to do that file bankruptcy is go to a mandatory hearing. Everyone is required to appear if they're filing for bankruptcy. Post-bankruptcy, we like to talk about rebuilding, helping folks by doing that, you know, applying for credit in a small way, making payments on time to rebuild your credit. And, you know, your credit's not done if you file for bankruptcy. You can get houses, get cars, have credit again in the future. So I think I'm supposed to wrap it up now.